Hello, everyone. Welcome to another episode of Easy Law. This is Attorney Chato Olivas. Recently, we heard news about Senator Laila de Lima being granted bail. After being detained for a non-bailable offense for more than 6 years, she's temporarily free while her criminal case is undergoing trial for drug-related charges. So in this video, I'd like to talk about bail. Specifically, I'd like to give 4 important points about bail. Number 1, bail is a guarantee by the accused in a criminal case that he or she will appear in court every time the judge requires it. When a criminal case is filed in court, an accused is required to be arrested and detained. He is also required to appear in court whenever the judge orders, such as when the case is scheduled for arraignment, pretrial, and trial. Arraignment is when the charges are read to the accused and asked if he pleads guilty or not guilty. Pretrial is when the prosecution and defense discuss the issues to be tried and the evidence to be presented. Trial is when the witnesses and evidence are actually presented in court. How does bail serve as a guarantee? As I said, the accused makes a commitment that he or she will appear in court when required. And if he or she does not appear, bail can be forfeited and the accused can be arrested and detained. Now, the second point is bail is required in criminal cases when the accused wants to be free, meaning not to be detained while the case is going on. This means that when the case is filed in court, a warrant of arrest will be issued. The accused will be detained while the case is going on. He can only be released temporarily if he posts bail. This is known as bail as a matter of right, meaning that the information, meaning the charge sheet, states how much the bail is, and when that is posted by the accused, he has temporary freedom while the case is going on. An information is the charge sheet that tells the accused what crime he is being charged with. Now, some cases are punishable by life imprisonment or capital penalty. That is non-bailable. This means that when the case is filed in court, the accused will be arrested and detained. But is it really non-bailable? The answer is that it can still be bailable. However, there must be proof that the evidence of guilt of the accused is not strong before the judge will grant him bail. So he has to apply for bail, and then the prosecution must present evidence that the guilt of the accused is strong. If the evidence is not strong, then the accused can go out on bail. We say this is bail as a matter of discretion of the court. This is the opposite of bail as a matter of right. The third point is there are 4 kinds of bail. Number 1, we have the cash bond. Number 2, we have a bail bond or surety bond. Number 3, we have property bond. And number 4, recognizance. So let us say that the information says that the bail recommended is 40,000 pesos. The accused can put up a cash bond of 40,000 pesos. This means that he or she will deposit that amount in cash to the cashier of the court and be issued an official receipt stating that this is the cash bond. At the end of the case, the cash bond will be returned to the accused. Suppose the accused has no 40,000 cash but wants to post bail. He can ask the office of the clerk of court for a list of the surety or bonding companies that are accredited by the court. From there, he can find out from one of the bonding companies how much is the premium for a bail bond of 40,000 pesos. This will be a percentage of the amount. He will pay the premium and he can be released while the case is pending because of this bond. There is a specific duration for the bond, let us say 1 year. If the case is not yet finished by the end of the year, the accused has to pay the premium for another year for the bail bond to continue being effective. If he jumps bail, meaning he does not appear without any valid reason, the bail bond will be forfeited and the accused will be arrested. The third kind of bond is a property bond. The accused or someone on his behalf will put up real property, for example, a parcel of land, as security for the amount of the bail. After the court approves the property bond, the fact that the property is posted as a bond in the criminal case should be annotated on the title on file with the Registry of Deeds. This will be annotated on the corresponding tax declaration also. Now, the fourth kind is recognizance. This is for minor offenses. The accused will be released based on the guarantee of a respected member of the community that the accused will appear in court whenever required. The fourth point about bail is an accused who is out on bail may be allowed by the court to travel outside the country subject to certain conditions. When an accused is on temporary liberty, he must be available to appear before the court when required. Before he can leave the country, he must ask for permission from the court to travel abroad. Now, if approved, the court will impose certain conditions such as duration of the travel, purpose of the travel, the need for similar travels before the criminal case was instituted, the ties of the accused in the Philippines, as well as the destination country, the availability of extradition, the reputation of the accused, his travel itinerary, including return tickets that are confirmed, return tickets to the Philippines, the possibility of reporting to the Philippine Embassy in the foreign country, and other similar factors. This is found in the case of Joseph C. versus Sandigan Bayan, GR number 237703, October 3, 2018. That's all for now. To know more about the laws and rules, subscribe to my channel, and remember to tell your friends about this channel. For now, I'd like to share my favorite Bible verse with you, found in Micah chapter 6, verse 8. Do justice, love kindness, and walk humbly with God. This is Attorney Chato Olivas of Easy Law Online, making the law easier to understand. See you next time.